Precedent Claims Tribunal, and accordingly the appeal is dismissed.
Mention, if any.
My Lord, I beg to mention one unlisted item. I had filed one writ petition yesterday, my Lord. It has been registered. This is pertaining to the recruitment process for the post of surveyor under the Revenue Department, my Lord. It is analogous with the other writ petition, which Your Lordship had extensively heard, my Lord. If it may be taken up tomorrow, my Lord.
Let it be taken up on Monday.
Monday, my Lord. Today, my Lord, is the last item, my Lord. If
No.
possible.
What is the urgency?
The urgency is that, my Lord, the examination is to be held next week, my Lord.
This is the same matter
Same matter, my Lord. All the facts are same, my Lord.
for
Because
surveyor post.
surveyor post, my Lord. BE degree holders are included in the valid list of candidates, my Lord.
So you wait for that judgment. That judgment will cover.
Yes.
Tomorrow I am going to deliver the judgment.
Yes, my Lord. So it may be taken up tomorrow, my Lord, because this is a separate selection process, my Lord. So the MPSC may,
No, you wait for the outcome of that judgment.
my Lord.
If it is in favor of, you see whether it goes in your favor or not.
That is true, my Lord.
Then there may not be necessity of, you may withdraw the writ petition also.
Yes, my Lord. That is why if it may be taken up tomorrow, my Lord.
Not tomorrow, on Monday.
My Lord.
I am giving you time to think after you go through the judgment tomorrow.
My Lord.
Okay.
Obliged.
Daily list for admission, item numbers 1 to 6.
Lordship, in item number 1, this IA is for Impleadment of Mr. Rajiv Dua as respondent number 13.
Give the outcome. Whose impleadment?
Mr. Rajiv Dua as respondent number 13. Who is the Chief Engineer Project Pushpak 1992.
Who is for the other side?
I represent the...
No, in this impleadment application, do you have any objection?
No, I cannot make any objection because I do not represent anyone.
Yes, we are allowing this impleadment. Whom you are seeking to implead?
Respondent number 13. Since the respondent number 9 changed the incumbent and this respondent number 13. Mr.
Respondent number 9 has transferred,
Yes, Lordship.
has been transferred. 9 is Chief Engineer.
Yes, Lordship.
Okay. Heard Miss Lalro Pari, learned counsel for the applicant. This application under Order 1, Rule 10, read with Section 151 of the Code of Civil Procedure, has been filed for impleading the new incumbent to the post of Chief Engineer Project Pushpak, Shri Rajiv Dua, as respondent number 13 in the connected contempt case number 16/2019. Start. Learned counsel for the applicant has submitted that the earlier incumbent to the post of Chief Engineer, who was impleaded in the connected contempt case as respondent number 9, has been transferred out, and in his place a new incumbent has joined, and therefore there is a requirement of impleading the new incumbent in the connected contempt case. Stop. Considering the submissions, the prayer is allowed. led Mr. Rajiv Dua, new incumbent to the post of Chief Engineer, Project Pushpak, care of 99 APO, be impleaded as respondent number 13 in the connected contempt case number 16/2019. The petitioner shall file an amended cause title in the connected contempt case number 16/2019 by impleading Shri Rajiv Dua as respondent number 13 therein. This interlocutory application is accordingly disposed of. Leads the connected contempt case after 1 week. After a week, you have anything?
I'm for respondent, my lord. For compliance with the court order, my lord, I may be granted 2 months' time because there is involvement of various channels, my lord. The DC already clarify our observation.
In which case? In
I-
all cases?
Item number 1. Item number 1, 2. Is that me?
Item number 1 to 6, are they related to the same order?
Or to 14. 1 to 14.
It's covered by the same award.
Same order.
Under same award.
Okay. Item number 1 to 6. Item number 1 to 6.
1 to 14, my lord.
I apologize to interrupt, Your Lordship. Before we proceed with the other cases, in item 1, Your Lordship, in light of the order passed in the IA, a notice may be issued to the newly impleaded incumbent, Your
Okay,
Lordship.
I'm sorry.
No, but before that, the cause title has to be amended.
Very well, Your Lordship.
So after a week, that order will be passed.
Very well, Your Lordship.
We are giving time to the,
If I may permit it, produce my instruction letter, my lord.
no, we are you have any objection?
No objection.
We are okay with the attempts being made by the respondents. However, Your Lordship, if the matter may be taken up after 4 weeks, so that status update can be given to this honorable court. If they need more time, definitely we will not object, but
Okay, item number 1 to 14. Heard Mr. Lalfak Wama,
yes, Your Lordship.
learned counsel for the petitioner. Also heard Ms. Zairem Sangpui, appearing for respondent number, appearing for respondent / contemnant number 379, who submits that she has been intimated by the, who has given you intimation? By the assistant engineer civil for chief engineer project Pushpak, that the process of implementation of the order dated 4th December 2025, in respect of which these contempt cases are filed, is still on, and sometime some more time is required for complying with the said order. She therefore seeks 2 weeks, 2 months time.
2 months.
2 months time for reporting compliance. On the other hand, learned counsel for the petitioner submits that he has no objection to the prayer made by learned Central Government Council, however, he prays for listing the matter after 4 weeks so that an up-to-date status of the process of implementation may be informed to the court. The prayer is allowed. Let these matters be listed after 4 weeks.
Yes, my lord.
March 16, Your Lordship. 4 weeks.
4 weeks. Oh, you want a fixed date?
If possible, Your Lordship.
Let this matter be listed on 16th of March.
Deeply obliged.
Oblige.
Common case, common order.
My lord, my learned friend, Mr. Fakome appeared for item number 1. And from item number 2 to item 14, similar order can be passed, and I'm appealing for the petitioners in all the
Name.
2 to 14.
You are appearing for?
The petitioners in all this case.
Same
Item number
order,
2 to
same
14.
order. Name of the council instead of right Alpha comma, right Victor L. Ralte. Remaining thing remains same.
Would be obliged.
Oblige.
Item 15.
Lordship, counsel for respondent number 5 is on legs in the other court, so if this matter may kindly be passed over for the time being.
Yes, what is the matter?
My lord, we challenge the cancellation order by revenue. Then in that order, we are owners of the land settlement certificate. We are not given any opportunity of being heard at all. And that is one point. Another point is that the state government blow hot and cold. Because in the district court, your past is invalid. And again, when they pass,
We will fix it on Monday.
Monday.
If it's...
I'll be in Monday. My lord, you'll be there on Monday?
No. Somebody will be there.
Adam.
My lord, it was about tomorrow.
No.
Whatever they wish to have it, can have it. I'm prepared.
Even the counsel for respondent number 5 is prepared, my lord.
Okay, we'll take it up after some time.
Item 16.
Your Lordship, I'm appearing on behalf of my senior, Mr. Cizaram Sana. So, my senior, he cannot respondent number 2, Mr. Cizaram Sana. So, my senior couldn't attend due to personal difficulties. So, if I can seek your permission, if the matter may be taken after 2 weeks.
Any objection?
No objection, but
Heard Miss H. Lalmal Sami, learned counsel for the petitioner. Also heard Mr. What is your
Isaac
name?
Laramrota. Isaac Laramrota.
Isaac Lal,
Laramrota.
write his name, who submits who appears for Mr. C. Zoram Chana, learned counsel for respondent number 2. Also heard Ms. Mary L. Kante, learned additional public prosecutor. Learned counsel for respondent number 2 prays for an adjournment on the ground of personal difficulty of the conducting counsel for respondent number 2. Stops. Considering the submission, the prayer is allowed. Let this matter be listed when?
Lordship, let it come after 2 weeks, if not fixed date.
You will fix it.
3rd of March.
3rd of March.
Obliged.
Item 17.
My Lord, this is an appeal against a judgment and order passing a review petition.
My Lord, before we take up the matter, my Lord, just make one or two mentions here, my Lord. My Lord, in this case, since this is an appeal from review, order from review, my Lord, we had sought the review in the district court, my Lord, before the original court.
Review of?
A review of a judgment which
and
was
order.
passed in that same court, my Lord, in the senior civil judge.
Judgment
eviction
in
suit.
title suit?
In an eviction suit.
Eviction suit, okay.
Now, my Lord, in that eviction suit, we had sought review on certain grounds because of discovery of new evidence, my Lord.
Okay.
And also some errors apparent on the face of record. Now, my Lord, these documents, all of them have not been enclosed in this petition, my Lord, in this memo. So my humble submission, my Lord, at this, and
They have appealed against the order passed in review.
there were, my
Yes,
Lord,
Your Lordship, that is
eviction
correct.
suit was there.
Review was dismissed,
Allowed.
Review was allowed,
allowed.
and they are aggrieved by that review order, my Lord.
Okay.
Now, my Lord, the records in that review petition, in the review case, my Lord, the entirety has not been enclosed in this appeal. So my humble submission is, my Lord, if we are going to take up, because I was preparing myself also, my Lord, and there are certain documents which we had relied upon, which have not been enclosed in this. So, my Lord, my humble submission is, if we are going to have this final hearing, disposal, either, my Lord, the appellants should submit them, my Lord, the entire records, or, my Lord, let this matter, let the paper book be prepared, my Lord, or some compilation be done by the registry. Otherwise, my Lord, we cannot have, it will lead to confusion during the hearing.
Whether trial court records were called?
Trial courts, they are here.
Records are there.
Yes.
Yes, regarding that, Your Lordship. Since this appeal is limited to the findings by the review court, the appeal is limited to the findings of the review court only. So if my learned friend feels that the documents which were enclosed in the review petition should be made part and parcel of the record, then I will make the necessary filing, Your Lordship.
My Lord, they have also submitted a written objection in the review.
We will submit
the review
everything.
case. Yes.
We will submit
My
everything.
Lord, it will be better, my Lord.
You are ready?
I'm ready. I'll file it within a week, Your Lordship. Paperwork will take time.
Okay, and trial court records have not been received.
It is here, my Lord. Trial court records, I think, is here.
It is not there.
It's not there?
It's not there, Your Lordship.
Because
It was not
in
called.
the previous, I think in the previous court date.
Heard Mr. Lalfak.
My Lord, let me make one submission, my Lord. I think the trial court records also have to be called. The reason I say this is, my Lord, because our main allegation is the
The
plaintiff
matter has been disposed of in the...
disposed of, and my Lord, it has been,
What was the final judgment?
now the finding
It
of
was
the
against
judgment,
them.
Eviction was allowed.
Eviction was allowed.
eviction was allowed, and then we filed a review, my Lord.
You were the defendant.
We were the defendant.
Okay.
And when we filed a review, my Lord, our main allegation, my Lord, was that the plaintiff number one was a...
Okay, we'll call for trial
Yes,
court
I think it
records.
will be better, my
Your
Lord.
Lordship, this is limited
Which
to
court? Which court?
Senior
the senior civil judge.
Aizol.
Aizol.
So it is... It has not... It has already been called for,
Yes,
but not received. Will issue reminder.
yes.
Heard Mr. Lalfak Wama, learned counsel for the appellant. Also heard Mr. Joseph L. Renkley, learned counsel for respondent number 1. On perusal of the office note, it dated 23/1/2026, it appears that though requisition for trial court records have been sent, however, same has not been received. It is submitted by learned counsel for the respondent that perusal of certain documents which are annexed in the trial court records would be necessary for consideration of the instant appeal. Hence, he submits that the hearing of this case may be taken up only after receipt of trial court records. Issue reminder for the trial court records. List this matter again on May.
2 weeks, Your Lordship.
2 weeks.
2nd of March.
2nd of March.
Obliged, Your Lordship.
Item 18.
Lordship, we have filed approval for respondent number 1 and 2, MADC. And if we may be granted further 3 weeks' time to file our affidavit in opposition.
Heard. Mr. Victor L.
My lord.
Ralte.
My lord.
Yes.
My learned friend is appearing for respondent number 1 and 2, the Autonomous District Council officials. And as for the respondent number 3 and 4, private respondents, I have taken steps upon the respondent number 3 and 4 on 4th of November. And as per the office note 6/2/2026, the ID card has not yet returned from both the respondents 3 and 4.
What is to be done?
If the registry may be directed to track the postal consignment.
Okay. Heard Mr. Victor L. Ralte, learned counsel for the petitioner. Also heard Mr. Lalvama Ralte,
Yes, ma'am.
learned counsel for the respondent number 1 and 2, who prays for 2 weeks' time.
3 weeks, my lord, if possible.
Who submits that he has filed power in this case and seeks 3 weeks' time for filing affidavit in opposition. Stop. The prayer is allowed. On perusal of office note dated 6/2/2026, it appears that the service report in respect of the notices issued to respondent number
3 and 4.
3 and 4 have not yet received by the registry. Stop. The registry is directed to place the postal track consignment report of the notices sent to respondent number 3 and 4 by speed post on the next date fixed. Let this matter be listed after 2 weeks. After 3 weeks.
6th of March, madam.
3 weeks.
5th of March.
5th of March.
I'm obliged.
Obliged, my lord.
Item numbers 19 and 20.
My lord, I am appealing for in item number 20, and I have filed one IA number 20 of 2026, seeking for impleadment of the Deputy Director of Food and Drug Administration under the Department of Health Services, my lord. In the connected writ petition, my lord, this 200 gas case, my lord, the said official was already impleaded on the last occasion, which I have enclosed in my IA at Annexure 1. In the connected case,
In item number 20,
yes, my lord. In item number 20, I have filed this one IA.
whom you are seeking to implead?
I am seeking to implead the Deputy Director of Food and Drug Administration under the Directorate of Health Services, my lord.
Deputy Director of?
Deputy Director, Food and Drug Administration under the Directorate of Health Services, Government of Mizoram.
Why he is required?
My lord, in the tender selection process, my lord, the comments of this proposed respondent was taken into account.
Okay, therefore he is
Yes, my lord. His presence is required for proper adjudication.
Any submission?
My lord, with regards to WPC 141 of 2025, We have received instructions to appear on behalf of Respondent 7 and will be filing our power within a week.
In which case?
The same case, item number 20.
For Respondent 7,
We
in
are,
item
we are
20.
disposing of the just a minute. I heard Mr. Victor, heard Mr. Victor L. Ralte, learned counsel for the applicant. This application under Order 1, Rule 10 CPC of CPC has been filed by the petitioner in connection with the writ petition number 141/2025, praying for impleadment of the Deputy Director within bracket Food and Drug Administration bracket close Directorate of Health Services Government of Mizoram as respondent number 9 in the connected writ petition. He submits that since the said Deputy Director has, what he has done?
He has made comment on the bidding in
On the
question.
bidding.
Bidding. It's a tender process, my lord.
Has given certain comments on the bidding, which is the subject matter of the connected writ petition, his impleadment is necessary for consideration of the connected writ petition. Learned counsel for the petitioner has submitted that the instant writ petition is similar to the writ petition number 141/2025 is issue in writ petition number 141/2025 is similar to the writ petition number 2 of 2025, and in the said writ petition the Deputy Director Food and Drugs Administration has already been impleaded, allowed to be impleaded. Stop. Considering the submissions made by learned counsel for the petitioner, the prayer for impleadment of Deputy Director within bracket Food and Drugs Administration, Directorate of Health and Health Services Government of Mizoram is allowed. Stop. The petitioner shall submit an amended cause title in the connected writ petition number 141/2025 by impleading the Deputy Director Food and Drugs Administration, Directorate of Health Services, Government of Mizoram as respondent number 9 in the said writ petition. This interlocutory application is accordingly disposed of. In the main writ petition, heard Mr. Victor L. Ralte, also heard Miss, what is your name?
Banal Thamwani.
Wallal Tlamwani,
My lord.
who submits that
We'll be filing our power within a week
That-
for Respondent 7.
that she would be filing her powers for respondent number
7.
7 within
My
a
lord.
week. The prayer is allowed. Also heard Mr. Joseph L. Rentley. You are appearing for
My lord, I'm appearing for respondent number 8.
respondent number 8. Let this matter be listed after 2 weeks.
2 weeks. And my lord, in item number 19, let the interim order, my lord, continue.
Item number 19, same parties.
Same parties. I'm the private respondent in that case. And Mr. Joseph, my learned friend, is for the petitioner.
Item number 19. Heard Mr. Joseph L. Rentley, learned counsel for the writ petitioner. Also heard Miss Linda L. Farmwell, learned additional AG, appearing for respondent number 1 to 6,
And 9. 1 to 6 and 9, madam.
1 to 6 and 9, as well as Ms. Vallaltha Mwani appearing for respondent number 7. Since the connected writ petition, that is WPC 141/2025 has been listed after 2 weeks, list this matter along with the said writ petition after 2 weeks. The interim order shall continue till next day.
Deeply obliged, madam.
Much obliged.
Item 21.
What is this?
My Lord, IA number 199 of 2025. This is for seeking to implead the present incumbent of Revenue Secretary in the connected contempt petition as respondent number 7 due to transfer of the previous incumbent. Sri Vanal Moya, Secretary, Inland Revenue and Settlement Department, Government of Mizoram. In place of who the previous incumbent was respondent number 3.
We are allowing this.
Yes, madam.
Though notices have been sent to the person to whom you...
My Lord, regarding that, my Lord, I've clarified, my Lord. I have belatedly found out that at the time of furnishing the judgment order, the said respondent which we are proposing to implead was already holding the post.
Was?
Already holding the post, this post.
Okay. Then why he was not impleaded earlier?
It is a mistake, my Lord. And at this stage, my Lord, we are seeking to implead this person.
In whose place you are
Respondent number
seeking?
3.
In place of respondent number 3,
Yes, my Lord.
heard Mr. Victor L. Ralte, learned in the IA, heard Mr. Victor L. Ralte, learned counsel for the applicant. This application under Order 1, Rule 10, within bracket 2 of the Code of Civil Procedure 1908 has been filed by the petitioner in connection with contempt case number 17/2025, praying for allowing the petitioner to implead Shri Vanlal Mauya, the present incumbent, to the post of Secretary to the Land, Revenue and Settlement Department, Government of Mizoram, as the earlier incumbent who was impleaded as respondent number 7 in the connected
3.
respondent number 3 in the connected contempt case has been transferred out. Stop. Considering the submissions made by learned counsel for the applicant, the prayer is allowed. Let the present incumbent to the post of Secretary, Land Revenue and Settlement Department, Government of Mizoram, namely Shri Vanlal Mauya, be impleaded as respondent number 7 in the connected contempt case number 17/2025. The applicant shall submit an corrected and amended cause title showing the name of Shri Vanlal Mauya as respondent number 7 in the connected contempt case. This interlocutory application is allowed. The connected contempt case may be listed after 2 weeks from the date of this order.
Deeply obliged.
Item 22.
May I please, Your Lordship?
Yes.
My Lord, this is bail application.
Yes. What is the matter?
My Lord, the applicant was arrested by Lunglei Police on 26/4/2025 at 11 p.m. for alleged involvement in the seizure of 32 grams of suspected heroin.
32.
Yes, my Lord.
Okay.
Which was not seized from their possession, which was seized from a public place, from a nearby place. My Lord, if I may take Your Lordship to page 44, the retyped copy of seizure memo.
Yes.
If I may read, my Lord, on 26/4/2025 at 11 p.m. on the unpaved road below one jungle hut near Longbridge, Pupui area, I made the below mentioned seizure from the possession of accused Ladingpui and Lalrampari. Ladingpui, my Lord, is the instant applicant, who were seen at the place of recovering of the seized article along with one scooty MZ01 so-and-so owned by the accused Lalrampari. Prior to seizure, both the accused had run away from us. On seeing the duty party, we immediately followed them, chased down, and subsequently recovered the seized article on the ground beside where they were standing at, and no other person suspected to be involved was found near them at this late night. Seized article 32.84 grams of suspected heroin kept inside 3 soap cases, so-and-so. Each soap was wrapped in a mummy pack. Weighment, packing, and sealing were done at the spot in the presence of the accused person and witnesses. Then, my Lord, there are 2 signatures of the seizure witnesses. And, my Lord, the next page is the arrest memo.
Your submission is that the contraband was found from the ground,
Yes, my Lord.
not from your position.
Yes, my Lord. Also, my Lord, there is violation of Article 22 of the
How?
Constitution of India,
How?
that intimation of arrest was not informed to their relatives in writing and grounds of arrest was not informed.
48 was not followed.
Yes, my Lord. My Lord, which is evident from page 46 in the arrest memo.
Yes.
There was intimation of arrest was also informed to their relative of the accused. Only that much is written.
Where?
My Lord, at page 46 is the retyped copy of arrest memo. My Lord, in the 3rd paragraph.
Intimation was also informed to the... What is the requirement, legal requirement?
My Lord, the requirement is that it should be given in writing. And there should be proof that they were duly informed for the reasons of arrest and the grounds of arrest.
The case is pending investigation.
Yes, my Lord, it's pending in the trial court.
Since when you are... No, it is pending investigation, or whether charge sheet has
Charge
been
sheet is already filed, my
laid.
Lord. Yes, my Lord.
Then you have you moved an application before the trial court?
Yes, my Lord.
Why it rejected your prayer?
My Lord, we had annexed here.
Where is the rejection order?
My Lord, page 34 and 36 to 36.
Before the trial court, did you took the plea? Did you take the plea that
Yes, my lord.
the relatives were not informed? Page number?
Page number, my lord, from 34. My lord,
How-
from page 36, sorry, my lord, page 36.
Page
My lord,
36?
page 34 is the first bail application which granted bail by the trial court.
Bail was granted to you?
Yes.
Then what happened?
Then subsequently it was cancelled because she was on medical checkup, and then bail was again applied, which was rejected.
Where is the, once earlier, that means on one occasion bail was granted to you?
Yes, my lord.
On what ground? Medical ground?
Yes, my lord. Page 34.
Okay, thereafter 36A,
Yes, my lord.
it was rejected.
It was rejected.
Why? Whether,
My lord, page 36B, the next page, the last paragraph.
Yes.
After hearing and on careful perusal of both submissions, it is seen that from the record the accused is on bail and notice was issued to the sureties. The medical certificate dated 31/10/2025 is doubtful and has stated that Lading Pui has again been admitted on so-and-so date at Swagat Hospital for operation by order dated 18/7 so-and-so in bail application so-and-so. Accused petitioner was granted interim bail for a period of 1 month on medical ground. Thereafter, another bail application was filed and by order so-and-so, this court rejected the said application. The interim bail period had lapsed on 18/8 and
No, before the trial court you did not take the plea that,
Article 21.
yes, section 48.
Yes, my lord.
You have not taken that plea?
Yes, my lord.
Yes
It
or no?
seems- No. My lord, I'm not the trial, I'm not the counsel in the trial court, which is in another district at the southern
No,
side of
somebody
Mizoram.
is there.
Yes, somebody is there, but it seems that they haven't taken the plea of
Okay, what
violation
else
of
what
section-
else is your submission?
Pardon, my lord?
What else is your submission?
My lord, basically it's the medical, I think. They have not taken any technical grounds.
No, you are now seeking bail on 2 grounds, that it was not found from your possession
Yes, my lord.
and that section 48
Yes, my lord.
BNSS was,
Yes, and medical grounds.
and medical ground also.
Yes, my lord.
What is the medical ground?
My lord, medical ground is... My lord, it starts from page 14. My lord, which I had stated in my bail application at page 6, para number 3.
With what, which ailment you are suffering?
My lord, if I may read from para 3 at page 6.
What is the
It is humbly submitted that the accused applicant is diagnosed with large ovarian cyst measuring 4 by 4 centimeter and requires urgent surgical intervention. Also, the applicant accused is also suffering from renal kidney problem, hypertension and liver problem due to narrowed...
Now, whether operations have been performed?
My lord, operation has not been performed yet because her vitals were not stable.
Okay. Okay, anything else?
And my lord, the applicant is recommended to undergo renal artery bypass surgery accordingly, that I have stated here. But my lord, those were the main grounds that we
Yes,
had.
Miss Linda. The notice to the relative,
My lord,
22.
Intimation was given to the relatives, my lord, as
Where is the
said
proof? Where is that notice? Merely by writing that you have given intimation, is that enough?
My lord, we have to go by what is written, otherwise, I don't think the TCR has given any other documents regarding that.
Whether the scanned copy of the case diary is there?
Yes,
If-
my lord, the TCR is,
Scanned copy of the case diary is there.
not
s-
case diary, my lord. Case diary we have not got.
How intimation was given?
My lord,
In what manner? It has to be in writing.
information, my lord, not in writing, my lord.
No, intimation has to be given in writing.
It's written here, intimation was informed to the relatives, so it's
That is not
just
sufficient.
information.
You check from the trial court records. Otherwise, for violation of section 48, they will get bail.
That is true, my lord.
What is your submission?
My lord, my submission is that the petitioner is a habitual offender.
No. Those
Regarding
things
that.
will not help you. Whether the arresting authority had complied with the mandate of section
lord.
48.
Whatever we can see is from the TCR, my lord. The arrest memo, in the arrest memo, it's written that intimation of the arrest.
Apart
was-
from that writing, is there
Apart
any?
from that, my lord, no. We don't have any.
Verify.
It's not there, my lord.
If nothing is there, then there is a violation of section 48. Are you relying on some authority?
My lord, if I may be granted some time, I'll contact the case IO and see that if any information is given.
How much time?
My lord, Monday next week.
My lord, the charge sheet has already arrived, and in the complaint sheet, nothing is written with regard to the compliance of section 48.
No, you
Yes,
take intimation by 2 today. We'll take it up at 2. You take telephonic information. Whether anything in writing was given. You verify from the record which is before the court. Trial court records are there. Scanned copy of the TCR. But it may not be in TCR.
Otherwise, my lord, tomorrow.
No, not tomorrow.
Then, my lord, I'll try to contact, let it come up after part 1. I'll try to
Yes.
contact.
We will take it up at 2 today.
My lord, can it come up before 2, my lord? I have
Yes.
some problems, so
Yeah.
after part 1, I'll try to give the information.
Okay, let
My
her.
lord, if I may submit 3 citations, Prabir, Purkayastha, Vihan Kumar, and Mihir Rajesha.
Okay, you keep ready the citation. Let her find out. Miss Linda, you find out whether anything in writing was given or not.
Item 23.
If I may, my lord, this IA is for condoning the delay of 96 days in filing the connected revision petition.
You are objecting? No objection. Then we will condone the delay. Heard, Mr.
My lord, this is a legal aid case. Can it be reflected as a legal aid counsel?
What is your name?
Lalram Dintara.
Heard, Mr. Lalram Dintara, learned legal aid counsel,
Yes, my lord.
appearing for the applicant. Also heard Ms. Linda L. Farmwell, learned public prosecutor, appearing for the state respondent. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant Lalbyat Dingi, who is praying for condoning the delay of 96 days in filing the connected revision petition, by which the petitioner has impugned the order dated 5/8/2025 passed in criminal misapplication number 61/2025 in connection with Bangkwan PS case number 420/2024 by the Court of Learned Special Judge NDPS Act, Aizawl. Learned Counsel, why delay? Because of
Mainly financial constraint, my lord.
Learned Counsel for the Learned Legal Aid Counsel for the applicant has submitted that the cause of approaching this court beyond the prescribed period of limitation has been mentioned in paragraph number 2 of the instant interlocutory application. He submits that these reasons shown were beyond the control of the applicant and hence same may be regarded as sufficient cause. He therefore prays for condoning the delay of 96 days. Ms. Linda L. Fambel, Learned Public Prosecutor, stop, considering the reasons shown by the applicant in the interlocutory application, does not raise any objection for objection against condonation prayer, against prayer for condoning the delay. Stop. After considering the submissions made by Learned Counsel for both sides, as well as considering the reasons shown in the instant interlocutory application as sufficient cause which prevented the applicant in preferring the connected revision petition within the prescribed period of limitation, the instant interlocutory application is hereby allowed and the delay of 96 days in filing the connected revision petition.
Engineer, construction convoy note is Frontier Railways, my lord, to implead him as the respondent number 6 to the contempt case number 8 of 2023, my lord.
Who was the
On the transfer of the respondent number 5, my lord.
respondent? Okay. Heard Miss Valentina Laldinpui, Learned Counsel for the applicant. This interlocutory application under Order 1 Rule 10 read with Section 151 of the Code of Civil Procedure 1908 has been filed by the applicant in connection with the contempt case number 8/2022, praying for impleadment of the new incumbent to the post of Deputy Chief Engineer / Conpui, Northeast Frontier Railway, as respondent number 6 in the connected contempt case. The name of the new incumbent to the aforesaid post is Shri Arvind Kumar Meena. Learned Counsel for the applicant submits that the earlier incumbent, who was impleaded as respondent number 5 in the connected contempt case, has already been transferred out. Stop. Considering the submissions made by Learned Counsel for the applicant, the prayer for impleadment of Shri Arvind Kumar Meena, Deputy Chief Engineer / Kwanpui, Northeast Frontier Railway, is as respondent number 7 in the connected contempt case is
Respondent number
hereby.
6, my lord.
Huh?
Respondent number 6, my lord.
Sorry, respondent number 6 in the connected contempt case number 8/2022 is hereby allowed. The applicant shall submit the amended cause title after impleading the aforesaid respondent in the connected contempt case within 2 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Much obliged.
Item 15 for admission.
Sorry, my lords, I was not available on the first call.
Lordship, here some facts needs to elaborate it first.
How much time it will take?
My lord, it wouldn't be taking time much. I have only 3 grounds.
My lords, from our side, my lords, the maintainability of this writ petition is being...
Maintainability?
Yes, my lords. That we are going to, my lords, submit on that aspect, my lords. What my learned friend wants to see on facts, my lords, that, my lords, that's on him, my lords.
My lord, that, not that a long fact. I may finish within 15 minutes. Then on law point, I have three grounds. Then I can finish up, I think, within 30 minutes with some citation, 3 citations.
15 plus 30, 45.
I'll try my best, Lordship.
You.
My lords, we won't take time on this side.
Still, let me...
Yes, ma'am.
Give me an idea how much time.
My lords, from my side, my lords, 15 minutes max, my lords.
What is the issue involved?
My lord, so issue involved is like cancellations of LAC, my LAC, land settlement certificate.
Cancellation
Yes.
of?
Land settlement certificate.
Land settlement certificate. Okay.
So, Your Lordship, actually, you're conscious of the time. That is very important now.
My lords, there is a land title based on which they, my lords, they say they have a right to the land. We also have.
No, my lord. What I'm
Their
talking.
title, my
No,
lords.
why I'm putting these queries?
Yes, ma'am.
Because tomorrow is my last day.
We understand.
I want, if I hear, I want to dispose it off before
Yes.
going.
My lord, it's short. It's very short. My point is also very short. It's all settled law.
Okay. Let
So,
us
my
hear.
lord, actually, time is very important now, because now what recently Supreme Court instructed us to do. I'm advocate on record at Supreme Court.
No,
so
that,
they
that
inform
may not
us.
be very relevant in Aizawl.
Yeah, actually, they inform us how long you are going to take time. We have to submit before in our portal. So then we have to specifically mention the time we are going to take in Supreme Court.
No, in that context, here we have sufficient time.
Yes.
My query was on for some other reason.
Yes, my lord, here, let me just go straight to my petition. So here the story, it started from filing of civil suit. It's at page number 26 of the writ petition. You're there, Lordship? 26.
26. Yes.
My lord, respondent number 4, she was ex parte in this case. Respondent number 4 in this case filed this civil suit first in the 2015. So her claim is, if you kindly see,
Respondent number 4 of this,
in this petition,
petition
was the plaintiff in this claim in 2015.
Who is representing?
She was not
respondent
represented
number
anymore. She was ex parte.
4? Okay.
Actually, their same cause of action, and she was defended by the respondent number 5. If you kindly see page number 32.
Why this civil suit was filed? What relief?
She claimed that she purchased this village council pass from Kap Chianga. If you kindly see page number 32.
Yes.
And 33 is the English translation. So she claimed that she purchased this suit property. Your Lordship, kindly look this one, the boundary description in the original one. This is the past. Kindly look the boundary description. If you see frontage, it was left blank. Depth, it was again left blank. You're there, Your Lordship?
Yes.
And base also left blank. See, this VC pass was presumably issued in the year 1970 by the President Village VC in that Aizawl city. So, my lord, the next one is the transfers of instrument, transfer of the land. 34. So, she claimed to have purchased from this. Actually, we don't know whether this Kap Chianga belonged or existed or not, but she claimed to purchase from some other person. If you see here, English translation is 35.
Yes.
So, but
what you want to show?
I want to show is that this was the sale deed. That the sale deed was never registered as per law, as per section 17. That I'll come the law point. I just want to apprise the court the fact of the case.
Who was the seller?
The seller is some other person, B. Lalmangai, at the left corner. In fact, they are sisters. So this is how the story started, the problem started. One person had VC pass in 1970. It was not at all clear and it was really disputed, and boundary description was not at all there. So then she claimed to have purchased that VC pass from another person where the title was not even established at all. So, my lord, I am holder of settlement, land settlement certificate. So, your lordship is very aware of
what happened to this civil suit?
My lord, the civil suit was withdrawn. I'll show you to the order also. We filed written objection, and that the same was withdrawn on 58, page number 58. Very short order.
Yes.
Lordship, counsel for the plaintiff pray to withdraw the said case with liberty to file afresh due to discovery of new fact. My lord, actually, the very short contention of our written objection is that notary was not at all notary when that sale deed was notarized, one point. Another point is that it was not registered, and another one, she did not have locus standi. We filed it, and it was barred by law, Lusa Hill District Council Act 1953. 3 points. We filed it, and they withdrew. That is first withdrawal. And that in the same line, they changed only the notary. That they changed the notary, and again they filed. If you lordship again at the next page, 60. And everything in same line.
Sankumi.
Yes, be the same respondent number 4 here. And everything same.
Okay.
And, but here, the difference is that if you see 67, the sale deed,
Yes.
here the notary became another person. If you compare, here he is S.L. Thansanga. And if you compare the first one, he was another one, Thangkanglova.
No, I am not getting it.
Actually, my lord, here
What you want to say?
It is not clear. In the first sale deed, the notarized was Mr. Thangkanglova.
The notary was different.
Different. And the subsequent, when they filed it again, the notary is Mr. S.L. Thansanga.
So, what you want to say?
I want to say is that this is the only difference when they file it again.
Okay.
2015 they filed, they withdrew, and again 2016 they filed it again.
Okay.
And we filed written statement also. Even the state also filed written statement also. So our contention still the same, but the state government filed written statement. If you kindly see their written statement,
You were respondent number 2.
I am the petitioner's hearing.
No, in the civil suit,
Yes,
defendant
Your
number?
Lordship. Yes.
Defendant number?
Defendant number 1 and 2.
Who is the petitioner here?
In years here, we are the petitioner 1 and 2. Because our LSCs were cancelled by the state authority.
Okay.
My lord?
Thereafter?
Yes.
Thereafter what happened?
Yes, then we come here. My lord, kindly go to 81, page number 81. This is very crucial. Written statement filed by the state in the plain.
Yes.
So, my lord, this was submitted by the state respondent before the trial court. My lord, relevant part is at para 9. Page number 82.
Yes.
May I kindly read?
Yes, please read.
With regard to para number 2 of the plain, answering defendant would like to state that VC pass number 2870, which is said to have been brought by the plaintiff, has no legal validity. The same was issued in violation of notification of the Answell, Mizo District Council, where allotment of site shall be done by the village council only with previous approval of the executive committee of the Mizo District Council. The said notification dated 9 June 1960 was published in Mizo Hriatirna. This is Mizo Gazette, dated 15 June 1960, which was official district information of the then Mizo District Council. So, my lord, this point that the trial was proceeded for so long, from 2016 to 2021, it was proceeded, and evidence was taken, and they closed their evidence. The respondent number 4 herein closed her evidence, and we are about to start our evidence. Then we did so well at cross-examination, everything, because what is required to issue VC pass is, as per section 4.2 and notification, approval of the government is required. But there was no such approval. Even the state government themselves stated that approval of the government is required. And unsurprisingly, we came to know that they withdrew again the case.
The
So-
second suit was...
Yes, again. They filed application at 99 without our knowledge. Withdrew, they filed application on 25th February 2021
Where? Which page?
at page number 99.
Yes. Yes.
Here, they file application and it was allowed in our absence by the trial court and they filed. So, my lord, their
Where
reason...
is the order which...
the next one, 101.
Okay, with a liberty to file a...
Yes, again. My lord, here permanent to submit here is that the husband of the, here the plaintiff, here the respondent in this case is very prominent officers of Mizoram, and he, after he retired, and he joined the ruling party, MNF, and he was advisor to MNF. So even he himself was the witness in the cell deed also. One of our pleading here, our pleaded case is that they used political pressure. So then they withdrew, and we came to know that we'll take step in the revenue offices from the government. And that's, we heard that. So then, Your Lordship, we don't want this suit to be withdrawn. We did not have objection. So we filed a review of this withdrawal application. So it is there also, and the review was not, my review was not allowed. It is there in 129. Because the judge said, if someone want to withdraw, why do you object? We don't have any authority to object. And my review was dismissed. 129. So then, this order came, impugn order. My lord, shall I take you to the review order, 129?
Yes.
Yes. But my review was not allowed. Because we want to settle in the district court. The suit was filed in 2015. They have stay order. Then after that they withdraw. Again 2016 they filed. They applied stay order, but stay order was not granted. But we started making construction. In fact, we have some of our tenants in the suit place itself. We have building, construction, everything. So since 2016. But they keep disturbing in the court. And they withdrew in 2021. But all of a sudden, very shockingly, we came to know that they filed a civil suit in the district court for evictions of our tenants.
Fresh civil suit.
Fresh civil suit.
Okay.
So, my lord, then we did not have the order that, my lord, kindly go to the impugn order, eviction order. This is the subject matters of this case, 129.
129 is...
My lord, actually, before...
129 is the order passed in review petition only.
My lord, sorry, I'll take you to 133 first, because we are denied of the order, impugned order, 133. So this is the Mizo one, and the English version is 134.
What is this?
Here, we apply through RTR whether there is the order cancellations of our LSC. We deserve, we should be given an opportunity of being heard before cancellation, and we also deserve the impugned order for cancellations of our LSC also. So, but we are not given. And what they say is that we had the reply, we are denied, because some technical things is there, we are denied. And again, we file it.
No, when your LSCs were cancelled?
On LSC was cancelled on September 3rd, 2023. On 6. But before that, we don't know that. We applied 2 times RTI, through RTI. My lord, again 136, kindly go to again 137. In our second RTI application, and they respond that it is ready and you can collect. That's impugned order. Then,
which order is impugned order?
139, 6 September 2023. 139.
Yes.
So then this, if you kindly see the corner, the bottom, there is a seal, RTI response. This is we got through RTI. There is nowhere you will find that we received the order, impugn order at all. So we somehow managed to obtain through RTI this impugn order. There are two impugn order. Another one is that 20th September 2022 at page number 141. Your Lordship, may I kindly read the impugn order, the first impugn order?
Yes.
Whereas the plot of land within Brigade Phase 1 Bongkon, Aizawl, was claimed by Biak Kungi. This is the petitioner number 1 here. On the strength of LSC number 204 of 1989, Sai Kluang Pui Silo, this is petitioner number 2 herein. On the strength of LSC number 203 of 1989, and by Lian Chungi is the respondent number 5. Residents of Bongkon, Simveng, on the strength of Village Council Pass 28, 1970. That is the very same VC pass claimed to have purchased by the respondent number 4. My Lord, I just want to make a very small clarification. Here, another new name appeared, Lian Chungi. Here is the respondent number 5. Lian Chungi name never appeared in the claim. But at the disputed site, she is the one who used to come to the disputed site. Because the respondent number 4 was old man, retired officers. She did not come much, and she is her some of employees, or we heard that. So she
Lian Chungi.
Lian Chungi, and we pleaded as respondent number 5 in this case. Because kindly note that the VC pass was sold to respondent number 4 by 2 sale deeds. One, another notary, the second one, another notary. And that was all not registered at all. That is my point. But this new name came. In the first case, our pleaded case is that she did not have the right to claim, it was not registered in her name. The VC pass is another one, Kap Chianga. Another third party, we don't know whether he alive or he existed or not. And my Lord, I'll come to that. Whereas legality, validity of their claims was scrutinized and findings were stated below. LSC number 204 of 1989 was issued in the year 1989 by the then Assistant Settlement Officer without obtaining approval of the competent authority for allotment of land. The area of the pass is indicated as 1192 square meter. Location is marked as Bongkon Playground Mall. The disputed land did not fall within the area of Bongkon Brigade Playground Mall, and the holder of LSC number 204 of 1989 claimed the land which is not covered by the land pass. Also, the said land pass was issued without prior approval of the competent authority, hence it cannot be considered as a valid pass. And GLS number 203 of 1989 was issued in the year 1989 by the then. Everything is same with the preceding para. I'll skip, Lordship. Everything is same. Village pass number 29, 1970. The said pass was issued by the President Village Council Court, South Chalklang to Kap Chianga, son of Thanpara, Bongkon, in the year 1970. Location of the pass was indicated as Project Luikam Marparlai. Notification dated 9 June 1960. That is the notification I read out. As protected area where all allotment sites shall be done by Village Council only. Only is very important, with the previous approval of Executive Committee Chairman. Chalklang Local Council informed the government in the Land Revenue and Settlement Department that issuance of the said Village Council pass was recorded in their all record. I'll just stop for a moment here. My Lord, how can they just rely upon VC just orally informed that we had prior approval? Because it was already approved in the court, and even the state government already stated there was no executive approval. And orally the authority they informed, and it was admitted. The chairman, Chalklang Local Council informed the government in the Land Revenue Settlement Department that issuance of the said village council pass was recorded in the old record. The then President South Chalklang Village Council, who issued the said village council, made an affidavit. This is affidavit is important, that approval of Mizo District Council was obtained for the issue of village council pass number 28, 1970. As such, village council pass can be construed as a valid pass. My lord, here in this case, the main contention is that the state government had to reply. If you kindly see the state government very plain, then they did not enclose this affidavit also at all. They did not say that the statement also. There is nothing enclosure, there's nothing such kind of affidavit. Now, therefore, competent authority declared that LSC number 203 and 204 of 1989 cannot claim the disputed strength on the strength of the said passes, and they can be cancelled in pursuance of the order such and such, and then there's hereby cancelled. And that's the next one. Impleadment order is very short. As per the government notification, that is the earlier order issued by the secretary, the village, then the LSC number 204 and 203 issued by village has been cancelled due to overlap on the land of Kapchianga. My lord, here kindly note that the first order was passed by commissioner. If you see 140, the last right side.
Yes.
But he dare not to issue in his name, and it was issued in under secretary name, and it was passed by commissioner. Then again, because normally hierarchy in the department is, it was done by the director and secretary it comes. But here this one came back, and again a second impugn order was passed by director. Again this thing also, the director dare not issue in his name, and it was issued by some junior officer, assistant settlement officer. And if you see this order and 140, page number 140, there are copy to PS, to minister. Why did they give copy to PS to the minister? And ours, our grief, we are the owners of the land. See, our names is not there. We are never called before deciding this case. No so-called notice was given, and everything was done our back. And even the order itself, they hide it. We could not get the order. Two times RTI, only we came to know this one, and we are able to get this order. And copy was not even given to the order. Even in order itself, while it was given to the minister, we are excluded. So, my lord, that is the fact. So, my lord, just...
Now an eviction suit is pending.
No, my lord, not pending now.
Pending. My learned friend is misleading this honourable court. In fact, they filed a rejoinder affidavit
I'll complete and
putting the orders and what has been filed before the learned court. They are not a party, their tenants are, who we say, my lords, because they don't have a valid right on that land. So we filed. And they filed that, my lords, before this honourable court.
My lord, my learned friend has not done his homework. I can show the withdrawal order of that case. It was filed before junior division. This is very big property in Aizawl. Because junior civil judges, they can take up only up to 5 lakhs. Even they filed the first suit before senior civil judge. You should ask your client also.
My lords, we've not received the copy of this.
My lord, that is...
In fact, my lords, your lordship should see the rejoinder affidavit filed.
No. After filing rejoinder, that is the court documents.
No, who filed this? Lian Chungi had filed this.
Yes, my lords. Respondent 5.
Against our tenants. Because we should be
lords,
also included.
This we are not aware, my lords, of this passing of this order.
But there are other councils appearing.
No, now this has been withdrawn.
Well, he is not the party appearing. Another council is appearing in district court.
lord, that should have been filed before this honorable court. Ample time was there, my lords. If
No,
it
my
was
lord,
done.
recently it was withdrawn.
My lords, if it is withdrawn, it is withdrawn.
Yes.
Then I, my lords, take back.
Okay.
Unfortunately,
fine.
my lords, we are not the same representing the parties before the district court.
Actually,
Eviction
he's
suit
not
is
the one
with-
who filed it, actually. Yes, it's true. But he's not the counsel.
No, you want to take instructions.
No, no, my lords, let it be, my lords, because it doesn't
Now,
have any-
now you are.
I finish
Now
my-
you are challenging the.
Yes.
And the cancellation of your land settlement pass.
My lord,
My
3
lords,
points.
this doesn't have a bearing. I was only trying to show the facts.
Yes.
As per our knowledge, it was pending, my lords.
It's okay,
They've
fine. My
withdrawn
lord,
it.
that is fact.
No bearing, my lords, on the present case.
My lord, I have 3 grounds.
This Lian Chungi is respondent number 5 here.
5.
And who are these?
Other two, my
The
lords.
defendants against whom they are your tenants.
My tenants. Because I told you I submitted, we constructed a building and we have been taking rent since long time back and it is well developed now.
This was also withdrawn.
Yes, my lord, again, withdrawn. My lord, I'll come to 3 grounds. One is, my lord, the petitioner here, they have no locus and there is no right to transfer the ownership from that VC pass owned by another third party Kapchianga to this present respondent number 5. My lord, before I go, I just want to submit 2-3 points.
No, one more query.
Yes.
This impugn order does not speak anything about respondent number 4.
Yes, exactly. But we should be impleaded.
Oh.
Because she was the one who claimed that this pass I purchased from my
She
sister.
claimed by filing civil suit.
Yes, in civil to
But,
she
but,
claimed.
but civil suits have been withdrawn.
Yes.
No fresh suit has been
Yes.
filed. Now, in whose possession the land is now?
Now
who
we
is
have physical possession and
That is disputed, my lords. That is disputed.
but why did they file a civil eviction suit? If we don't occupy it?
That fact is precisely why I said, my lords, the maintainability of this petition. There are facts which need to be, my lords, concluded by trial, my lords.
Well,
How can a writ court...
I'll come to that I want to counter because they filed counter affidavit. I don't need to reply the government counter affidavit because very plain and simple, they have not stated anything. Because it is the government who issued this impugned order. Kindly go to, Your Lordship, government counter affidavit at page number. Oh, my lord, it will be in another shelf.
No, no.
It is only 2 pages.
No, slow, be slow.
Yes, my lord.
Before going to government counter affidavit,
Yes, my lord.
this impugn order dated 6 September 2023, whereby this your Biak Kungi,
Yes.
as well as Saitluan Pui Sailo,
Yes.
these two are the petitioners.
Yes.
Their land passes were cancelled
Yes.
because it was prior approval was not obtained.
My lord, actually that is
On
not
what on what ground it was?
the issue is that the VC pass was valid because at the conclusion part, if you kindly see the conclusion part of this impugned order, I'll take you again to the
Which para?
last para, very last para.
Now,
This is their reason.
which para? In which page? 149 or 139?
Yes. So
Your-
here you kindly read 140.
Your pass numbers are 204 and 203.
Yes. 140 is the conclusion part, the reason.
Yes.
Because
Read,
the reason is at last 2 para. Because the conclusion part is always at the last para.
Okay, read.
Yes. Village Council Pass number 28 of 1970. The said pass was issued by the President Village Council Court, South Chalklang to Kap Chianga. Kapching is the original owner. In the year 1950, locations of
No,
the...
no, where are you reading?
My lord, at page number 139, last para.
139. Ah, yes, please read.
Yes. Can I read?
Yes.
The last para. Village Council Pass number 29 of 1970. The said pass
28.
was... Village Council Pass number 28.
Yes, 28 of
1970, the said pass was issued by the President, Village Council, Court, South Chaltang to Kap Chiang. Kap Chiang is original owner of the VC pass in the year 1970. Location of the pass was indicated as Project Lui Kam Lampar Lai. This is near the Project River. And the notification dated ED 714457 Aizal dated 9 June 1960. Declare Chaltlang South. This notification is very important. Declare Chaltlang South as protected area where all allotment of sites shall be done by village local council Aizol. Inform the government in the Land Revenue and Settlement Department that issuance of the village council pass was recorded in their all record. The then President, South Chaltlang Village Council Court, who issued the said village council, make an affidavit that approval of Mysore District Council Court was obtained for issue of Village Council Pass number 28 of 1970. As such, the village pass can be construed as a valid pass. So this notification declared the VC pass as a valid pass. This is what we challenge. On the basis that affidavit submitted, no affidavit by the then President, but it was not there in the record. But how can we accept the affidavit?
This notification, on the one hand, declared the land pass number 28 of 1970, which was issued in favor of Lian Chungi to be valid pass.
Yes.
It also cancelled the pass number 204 and 203, which were...
Yes.
Why it was cancelled? On what
because the affidavit stated that it was, at the times of issuance of the VC pass, approval of the government was obtained. It was submitted by in the affidavit here. Affidavit stated that approval of the government, district council was obtained. Because
in case of Lian Chungi's
yes.
pass. But in your case?
My case is that because they cannot directly cancel that. Even it might not be without prior approval of the government also. Because at the plane, we had 2015, they supported us. Our plane was valid.
No. Forget about plane now.
Okay.
The impugn order cancels your village, your land pass on the basis that it was without prior approval of the competent authority.
My lord, this is, it might be, but it was accepted in the trial court. They cannot blow hot and cold at the same time. They can
trial court, there is no decision.
No, my lord.
Only withdrawn suits are there which have, there is no decision of the trial court. What plea they took before the trial court.
Why did they say it so? Why did they say it was not approval? It was there, everything was there. And also, my lord, here that before passing of that order, we had never been given any justification, so cause notice also. We never know that. So, my lord, the reason is that even here, the order which we challenge, the second order, the LSC superseded, overlap the VC pass. Because here, in the 20th September 2023 order passed by the director, very short, only one sentence.
Yes, what is your submission?
Yes.
This 20th September order was passed cancelling your village
Pass.
passes because it
LSE.
overlapped with the
Yes, VC pass.
village
yes.
pass of
Yes.
Lianchungi.
Yes.
But in the earlier order, a detailed reasonings has been given
Yes.
that your pass was obtained without prior approval of the competent.
Yes. And Lordship here, the government contention. If you kindly see a very short one, only 2 para. If you kindly see their counter affidavit, what they stated about that fact.
Government is 1, 2, 3.
1, 2, 3.
Yes. Yes, what it?
My lord, here, the government just submitted at 1, 2, they just simply deny and read petition number 1 and number 2. You're there, Lordship?
Yes.
Para number 4. With regard to statement number 2 of the writ petition, it is humbly submitted that garden LLC number such and such were issued in 1989 by the then settlement officer without obtaining approval of the competent authority for allotment of the land. Therefore, they cannot be constituted as valid passes. Moreover, the area of the land is indicated as 192 square meters. Location is marked as Bongkon playground. As such, disputed land does not fall within the area indicated in the above, which is not covered by the pass. This is only 2 sentences they made, and another, they have not stated anything. And there is no enclosure. This is our enclosure only, the impugn order. My lord, before can I come to the point?
Yes.
Yes, my lord. One point is that the VC pass, transfer of the VC pass from the original order, Kap Chianga, to the respondent number 5 is illegal as per law. If you kindly see that it was illegal, ground number 1.
Then you file a civil suit.
My lord, civil suit, we can file it, my lord, but here it is admitted position. It is admitted position. And number 2 is that, I'll elaborate this point, Lordship.
Yes.
From the record, it is very clear, because it is, they themselves admitted in their pleading everything, even the government order, it is very clear that plot of land was issued by Kap Trianga in the 1970. It was, and even still, the VC pass was remained in the name of Kap Trianga 1970, where no boundary descriptions, all were left blank. And since it was issued in the name of Kap Trianga, there was no transfer in the name of even respondent number 4, even in the name of respondent number 5. So how can the court lose sight that admitted fact? It is clear, it is very clear now, they did not have the pass in their name still. Before issuing that impugn order also, during the whole trial court also, even now also. So how can they have locus standi? That is my point. And in that respect, I would like to furnish the judgment of the Supreme Court. Surah Lam, 2012, Volume 1 SCC 656.
Which point you want to emphasize?
My lord, the point is that the transfer from Kap Trianga is illegal as per law, and it starts from para number 9. Surah Islam 2012 volume 2.
Kap Trianga to Lianchungi.
Yes.
Is illegal.
Illegal.
Why?
Because there was no instrument affecting transfer as per law. It was not registered. There was no sale deed also. There is no gift deed also.
No, but can that be a subject matter of a writ petition?
My lord, but my lord, it is admitted fact. They did not deny that. Even there is no documents at all in this writ petition also. Even before the authority also. Nowhere.
Okay, which para you are?
I am referring para 9, 10, start from 10. My lord, this is the law. The law is quite para 9. Starting from para 10. It is number 662.
662. Yes.
May I read?
Yes.
Section 5 of Transfer of Property Act 1882 defines transfer of property as under Section 5. Transfer of property as defined in the following section. Transfer of property means an act by which a living person convey property in present in future to another person, living person, or to himself or one or more other living person, and to transfer is to perform such act. Section 54. Sale defined. Sale is a transfer of ownerships in exchange for a price pay or promise, or part pay or part promise. How sale made? This is all the laws, and I'll skip to section para 14. Section 17 of the Registration Act 1905 makes a deed of conveyance compulsorily registrable. We extract below relevant portion of section 17. Document which registration is compulsory, and these are the thing. And other instrument which purpose or operate to create, declare, assign, limit, or extinguish, whether in persons, in present or in future, any right, title, interest, where vested or contingents of the value of 100 rupee or upward, or any immovable property. The documents containing contract to transfer for consideration any movable property for the purpose of section 553A of Transfer of Property Act 1882 shall be registered if they have executed on or after commencement of the registration and other related laws Amendment Act 2001. And if such documents are not registered on or after the commencement, they shall have to be effective for the purpose. And here relevant is at 18, para 18. It is thus clear that transfer of 18. It is thus clear that transfer of immovable property by way of sale can only be a deed of conveyance, sale deed, in the absence of a deed executed, duly stamped and registered as required by law. No right, title, or interest in an immovable property can be transferred. My lord, my point here is that this is the concluding part. Here there is no dispute in the pleading, even before trial court also, even in the evidence before the trial court also.
No, which trial court? There is no.
My lord,
you are not against an impugn order passed by a trial.
Okay, then in this case, in this writ petition, there is no document here. One is that sale deed is required, and a deed of conveyance is also required as per para 18. In absence of a deed of conveyance, and also this is important again, duly stamped and registered as per law, no right, title, or interest in immovable property can be transferred. This is one point. And also this judgment was relied by our High Court.
No, it only it only clarifies the law that transfer of an immovable property can be by a deed of conveyance, sale deed or gift deed, any, and if it is more than value of 100 rupees, registration is required.
Yes, because it is value more than 100 rupees.
So then nobody is disputing that fact.
Yes, and also there is no documents of sale deed, even registered deed in this petition. And again, Lordship, the same line with this judgment, even this Honorable Court in advance passed an order. So, my Lord, the relevant part is from 21, para 21. This is Mizoram case. Section 17 of Registration Act 1908 deals with documents with registration is compulsory. As per Section 70, other testamentary instrument which purpose or operate to create, declare, assign limits, extinguish, whether present in future, any right, titles, interests, whether vested or contingents of the value of 100 rupees and upward, true or immovable property shall be registered. Thus, a sale deed of land having valuations of more than 100 requires to be done within 4 months from the date of its execution. In exceptional case, registrar may accept document for registration. This is the law. And here, 22 is Mizoram version. That is what we practice in Mizoram. Under the Indian Stamp Mizoram Amendment Act 1996. You're there, Your Lordship? 26. Para 26?
Yes.
22. Under Indian Stamp Mizoram Amendment Act 1996, in the case of sale of immovable property whose value exceeds rupees 10 lakh, stamp duty of rupees 47 plus such and such is required to be paid. Having noticed the legal position indicated above, this is the fact in this case. Let us again examine the two crucial documents in question, one dated 23/7/2007 and the other dated 24/7/2007, which have been discussed in the proceeding para 19 in some detail. Documents dated 23/7/2007 is admittedly not registered.
No, this is regarding that fact of that case.
Yes, in this case. So that is one point, my Lord. And second grounds is that it is barred by law. This, because if you kindly see the notification, Your Lordship, before that I'll take you again to the submission, the written statement filed by the state before the trial court. It is at page number 81 of my writ petition. 81.
Yes.
Yes, my Lord, here, this is in respect of the same subject matter, the same pass 20 of 1970, issued in the name of the same person. Here, the second para is, there is no absolutely cost title in favor of the plaintiff and against answering defendant. I'll skip that. Important point is that this para 9. Para 9. With regard to para 2 of the claim, answering defendant would like to state that VC pass 2870, which is said to have been bought by the plaintiff, has no legal validity. The same was issued in violation of the notifications of the Antwell Mizo District Council, where allotments of sites shall be done by the village council only with prior approval of the executive committee of the Mizo District Council. So, my Lord, this is the contention by the state. So, the notification, I'll take you to the notification, para 1, page number 119. This is the notification. Here, my Lord, notification is at page number 121. The relevant para is at 121, but it is very unclear, and the translated is 122.
Yes.
123 is the notification. In exercise of the powers conferred under Section 3, you're there, Lordship?
Yes.
Section 3 of the Lusai Hills District House Site Act 1962 as amended by Mizo District House Site Amendment Act 1959, Act number 1 of 1960. The Executive Committee of the Mizo District Council is pleased to declare the following villages areas as protected area where allotments of sites shall be done by village council only without previous approvals of the Executive Committee. These are the lists. 1. Lunglon in Lunglei subdivision. 2. Zone Huai, Zoutlang. 3. Chaltang South. These VC pass fall under the number 3. So, my lord, I would like to take you to the law that village the Mizo Lusai Hill House Site Act 1959. 1959. The Mizo House Site 1959. House Site Act 1953. House Site Act 1953.
You have it. Yes, 1953.
This notification was issued pursuant to this section 3(1) of this 1953 Act.
Okay.
I'll come to section 3. Section 3, very short act, only 3 pages. Section 3, allotment of sites. It started with allotments of sites. Allotments of
Yes.
sites. Allotments of site submarried.
Yes.
Subject to the provisions of subsection 2 of this section, a village council shall be competent to allot sites within its jurisdiction for residential and other non-agriculture purpose, with the exceptions of shops and stalls, which include hotels and other business houses of the same nature, notwithstanding anything in this act. The administrator shall have the power to intervene in all cases of dispute over any sites within the village, and the decision of the administration shall be final. This proviso is important, provided that administrator may at any time by notification, this is the very notification of 1960, declare that any village or a particular locality is a protected area where allotments of sites shall be done by the village council only with previous approvals of the administrator. My lord, here, this notification is the one I just have read. And that notification declared Chaltang South, if you see the past also Chaltang South, it was issued by Chaltang South Village Council President and declared that that particular place was a protected area. And in that case, where pass was going to be issued, prior approval of Executive Committee was required. But what the notification, the impugn notification accepted is that it was simply affidavit stated by some person. That's why the impugn notification was legally wrong, without adherence to the principles of law, of natural justice, or also to not adherence to the law by this section 3 of clause 1 and not notification. That's why it is liable to be set aside. And my lord, again, my third point is, it's very well understood that in this case, I have never been approached of being heard before cancellations of my pass, before issuance of these impugn 2 notifications. So we somehow managed to obtain this impugn notification only through RTI Act. We applied through RTI on 2 times. I'll take it again to on 6 October 2023. That's page number 133. And again, this we applied on 6 October 2023. On again, my lord, in this respect, I would like to submit very particular, say, same case with this case. It was decided by this court reported in GLR. Herein in this case, LSCs were cancelled. So, and the court, by the authority, Land Revenue Settlement, understanding that it was another Hydel Province, another government land, it is encroached, and there is no private land, but in this case, and they claim that here notice was issued, but there was no proof in this particular, the case I refer, and then the court, I would like to read the relevant portion.
Paragraph.
From Para 2. My lord, very short, only there, may I kindly read? Para 2.
Yes.
There is no dispute in respect of issuance of LSE in favor of the writ petitioner with regard to the lands.
Which para you are reading?
Para 6.
Yes.
Can I read?
Yes.
Para 6. There is no dispute in respect of issuance of LSE in favor of the writ petitioners in regard to the lands described therein by Revenue Department, Government of Mizoram. After issuance of such LSE, writ petitioners have been possessing the same after payment of requisite rent, therefore to the government, for cancellations of such LSE by the appropriate authority on the grounds of allotment of land in favor of the Power and Electricity Department. Reasonable opportunity ought to have been given to the writ petitioner to put their grievances. Since no such opportunity was given to the writ petitioners as being heard, it is submitted by Mr. such and such that there is a complete violation of principle of natural justice, and for that impugn orders cannot stand. If the land was acquired in 1973 in favor of Power and Electricity Department for construction of a substation, there was no reasons on the part of the Revenue Department to issue such LSE in favor of writ petitioner. Of course, after inquiry of direction of this court in connection with WPC 13 of 2006, facts revealed that land was allotted to Power and Electricity Department and writ petitioners hearing were present while making such investigation per directions of this court, and this impugn order was passed on the ground that the land had been allotted to Power and Electricity Department. That apart, there is nothing on the record to substantiate the claim of respondent that appropriate notice had been issued to the writ petitioner to show cause why LSE should not be cancelled, although such claim is averted in their counter affidavit. When there is no documents to that effect available for this court, such a statement of the respondent made through affidavit in opposition can be branded as a vague statement and can be taken into consideration in respect of issuance of show cause. This does not find any force in the argument advanced by Mr. Nelson Silo, Landed Additional Advocate General, in this context. It is reiterated that the counsel for the writ petition that at no point of time notice was served to any of the writ petitioners in regard to cancellations of the LSE in their name. It is submitted by Mr. P.C. Pusti that claims of the respondents with regard to issue to show cause notice to the writ petition cannot be accepted. Minus placement of documents is supported to the fact. In further support submitted by the counsel for the writ petition that their lands were allotted in favor of the Power and Electricity Department, Government of Mizoram, void LSC number, land list number 94, 2005, for after issuance of LSC by Revenue Department in their favor. But to substantiate the claim, Mr. Pushi, Land Council for this petition, failed to place any document to show cause allotment in favor of Power and Electricity Department on 7/9/2005. This being positioned, it cannot be accepted that the land was allotted, including to the land covered by LSC issues in favor of the writ petitioner after 9/7/2005. Inquiry made per decisions of this court issue in connection with WPC number stand at different footing. The court directed to make an inquiry whether the land under LSC issue in favor of writ petition herein belong to Power and Electricity Department. Inquiry was made in the presence of writ petitioners, number 1, and it was found that the land was allotted to Power and Electricity Department. Taking resource to the said inquiry report, impugn order was passed by respondent number 3, cancelling the LSC issue in favor of the writ petition, making of an inquiry in regard to allotment of land and cancellation of LSC issue in favor of writ petition are two entirely different matters. Before cancellations of LSC, it would have been appropriate of the writ petition to explain why LSC issue in his favor should not be cancelled, but no such opportunity was afforded to any of the writ petitioner to place his grievances case before the respondent number 3 before adopting such a decision. Cancellation of LSC void impugn order appears to be passed in violations of principle of natural justice by the respondent number 3. Such an order cannot sustain legally. Having considered all fact situations appearing in the face of the record and submission advanced by Land counsels for both parties, document annexed in support of the contention, this court is of the opinion that in the fitness of thing impugn order cannot legally stand. Accordingly, impugn order is set aside and quashed. Here, the only difference is that here land list was passed in this case in favor of Power Electricity Department. Here, VC, because in Mizoram VC was not strong, there is very negligible importance. So the process of having title in Mizoram is that first VC pass, first periodic pata, and house side. After that they have LSC. So my lord, in this case, it was issued to a private person, to another person, not the original owner claimed the ownership. Here, exactly square feet in my case. So my lord, another point is that my lord, if you kindly see the act of 2013, Mizo Land Revenue Settlement, Mizo Revenue Act, Land Revenue Act 2013. I'll take you to.
Yes. Yes.
My lord, again, in respect of this, I want one authority, Supreme Court judgment 19 regarding principle of natural justice. Without, it is well settled that if they are not given any notice, so-called notice, it violates principle of natural justice. Since I pleaded in my petition, so I'm obliged to submit the citation. It is 1973, volume 3 SCC, at very last para 11. Last para, may I read?
Yes.
This rule embodies the principle of natural justice requiring appellate authority to hear the parties. The order dated April 22, 1960 must have therefore been made after hearing both sides as provided by this rule. There is no express provision for review in the rule to which our attention was drawn, but we are not asked whether not required to express any considered opinion on the competent review we express no. We are, however, clear that if order, we are, however, clear that if order dated 22/1960 is to be reconsidered, then appellant must be afforded adequate opportunity of hearing and presenting his case. From this one I refer. This unwritten right of hearing is fundamental to a just decision by any authority which decides a controversial issue affecting the rights of the rival contestant. This right has its root in the notions of fair procedures. It draws the attention of the party concerned to imperative necessity of not overlooking the other side of the case before coming to its decision, for nothing is more likely to conduce to just and right decision than the practice of giving hearing to the affected parties. I'll not come to that. Here it is admitted that opportunity of being heard in the first case was given, but in the second case was not given. My Lord, here, if you kindly see, this order was passed by, again, impugn order. If you kindly look the impugn order, it was passed by Commissioner Secretary.
Yes.
So first, at page number 140. Mr. R. Zarzosanga. 140, you're there? First one, it was passed by Commissioner Secretary to the government of Mizoram. And again, 140, again it was confirmed by the director on 20th September 2023, by director. But this is very unusual. Normally, the hierarchy, it comes in the procedures, equity and principle, fair and natural justice. It comes from bottom to the top. And here, first it was passed by the commissioners, this impugn order, again confirmed by the secretary. So, my Lord, if you see Mizoram Land Revenue Act, so there is this chapter provide for revenue court. Even my learned friend also relied upon in this counter affidavit. It should be decided by revenue court, because it was not decided by revenue court at all. First of all, if you see here, first appellate authority in section 89, page number 24. My Lord, before that, I want you to quickly glance through this para, chapter 8 from 21, page 21. This is regarding the procedures of revenue court, appeals and revision. Because this is, their contention is that it should refer back to the revenue court. So here, revenue officers to be the revenue court. What is stated in 76. So, revenue officers are those assistant settlement officers, that junior officers. But this case, at the times of they file complaint, that they have not gone through the revenue court, and they have straight away go to the top. And here, this is the procedures of revenue court. Place of hearing is there. How evidence has to be taken is also there. And tribunals also has to be instituted, but Mizoram we don't have these tribunals. And my Lord, again, the way how procedures has to be adopted is there in 81. How evidence is to be taken, how someone has to be given, and also how to give evidence, and how to produce evidence, and documents
Which
also.
is the forum where cancellation of land settlement pass
My Lord,
has to be
there is no forum, that's why I want to come. Because
Wrong,
the
my
one,
lord. There is a judgment.
and there is here, and even 83 also there. If they give us any summons, fail to appear, 83 is there, how ex parte hearing was to be conducted. And there comes how order is to be made. And everything is there. This is the procedures before revenue tribunals, revenue court. So my lord, here, my point here is that the respondent has failed to comply with these provisions at all. And in fact, if you kindly see this 89, section 89, this is relevant. May I kindly read?
Yes.
89. First appellate authority, this is after passing the order, save as otherwise expressly provided, an appeal shall lie from every order passed under this act. But this order was not passed under this act. One, if such an order is passed by an officer subordinate to assistant settlement officer, the appellant may prefer appeal to settlement officer. This is, we call it MCS. Below MCS, there was another junior officer. It will go to settlement officer first. If an order is passed by settlement officer, appellant may prefer appeal to collector or director. And if an order passed by collector or director, appellant may prefer to revenue commissioners or secretary. This is how it should go. But my lord, in our case, that procedures was not at all followed. If they say that they have to go back to revenue authority, my lord, they are the one who already passed this impugn notification. There is no other place to go. And again, if you see second appeal also, because the impugn notification, the foundation of this impugn notification was the order passed by the commissioner. And second appeal, presuming that we should avail second appeal also. If you read section 90, second appeal shall lie against any order passed in the first appeal. We can go to appeal also. But if an order passed under 89, just above, appeal may prefer. Appeal may be preferred, appeal to the, English is not, construction is not right, to the tribunals. And an order passed by the tribunal shall be final. So my lord, here, that impugn notification which we challenge was passed by the commissioner. Decision was made by the commissioner. And since there is a violation of principle of natural justice, as passed by the coordinator of this bench in that Lal Zidinga case which I referred, and also there are many judgments also passed by the Supreme Court also. So this impugn notification in all respect must go. My lord, I want to...
Under the Mizoram Land Revenue Act 2013, which is the competent authority which can cancel a
the
land
revenue court, which is at my notes.
But why it was
76, section 76.
But why it was cancelled by, he admitted that it was cancelled by incompetent officer.
If I may, my lords, just put my submissions across. My learned friend can rejoin if he wants, my lords.
My lord,
because I will not take time.
Mark his words and noted that, but the authority to cancel the LSC is Revenue Court by section 76. But it was not cancelled by Revenue Court. It was cancelled by the commissioner. My lord, if required, and my lord, you are well aware that 226 we can approach, to the court, High Court, though there is alternative remedy, but principle of natural justice is violated, we can directly come. There are many long line of judgment, content of judgment. In November only, 3 judges of Supreme Court, October 16 also 2015. I can furnish those long lines of judgment. But it is already understood. It is already understood. It is decided by the court.
If I may put my submissions across, my lords, it will save this honourable court's time.
I don't submit that. I can directly approach Honourable High Court since there is a principle of natural justice. Because it is admitted position. Nowhere that notice was given to them. Someone was given to them. And there was nothing such.
My lords, if I may just put...
Just a minute, before that. One or two queries too. This order, impugn order, has been passed in which proceeding?
My Lord.
Why it was passed?
My Lord, that is what my pleaded case is, that this is under the political pressures from the ministry, because there was no complaint also. There is no complaint at all. It was not there in this petition also. To make, because even they file a claim, but at least to revenue, they should make a complaint, a written complaint also. Just simply by using the power of the advisor to MNF ministry, this was passed. They did not deny. Even in my pleading, I submitted many times, but they never countered that fact. So that is admitted fact. They use political powers. Even copy 2 was given to minister. Why not to us? Why to the minister, Land Revenue and Settlement Department? It was not passed under any proceeding. It is totally against the law, without any jurisdiction.
Okay. Yes, Mr. Zordan.
My lords, this order, your lordships had posed the query, who has it been passed by? It has definitely been passed outside the Act. It seems to be, my lords. But at whose behest, my lords? Your lordships, we come to page 105 of the petition. I am saying, my lords, this submission and this portrayal of the case that, my lords, this order has been passed behind the back of the petitioner is, my lords, unsustainable because of this one document, my lords.
Page number?
Page 105. Your lordships has it?
Yes.
My lord, this is a translated version. It is a letter dated 8th of November 2021, Annexure 11. This is, my lords, it seems to be the initiation of what led to and culminated into the final impugned order, where my lords, they have requested not to proceed with any action against the VC pass to which B. Sankhumi, the to the respondents, initiated proceedings against us. This is the letter, my lords. Your lordships would have the last page of this representation at 107. Since you have previously stated that B. Sankhumi is valid, I request that B. Sankhumi, Liansungi or any other person who attempt to disrupt us during using this VC pass be given no support initiative, 8th November 2021. Below are the petitioners. Your lordships.
Read this.
Yes. My lords, if I...
Yes, no, what you want to say that by this letter?
My lords, this letter, which is the letter of the petitioner themselves, this had culminated into the impugned order they are challenging themselves today. It is not that the proceedings had taken behind their back, had happened behind their back, my lords, and they were caught by surprise. This letter, which I have shown your lordships at page 105, is the start of what led to the impugned order at page 139.
Yes, please read.
My lords. Subject, a request not to proceed with any action against the VC pass number 28 of 1970 to which B. Sankhumi Liansungi initiated proceedings against us. And your lordships may see at the top to whom it is directed. To the Secretary, Director and Joint Director, Land Revenue. So I request you to kindly peruse my statement below and take
No, it gives an indication that some proceeding has been initiated by 4 and 5.
Correct, my lords.
What proceeding?
That is what, my lords. It is
Well,
all I'm trying.
I'll just clarify.
No. Do not interfere.
I'll come back to you. Write down any point which you want to emphasize.
My lords, my point is this, that my lords...
No, before that.
Yes.
Miss Linda, we will take up that bail matter. You have taken instructions?
Yes, madam.
You have taken...
No documents, madam.
Okay. Okay, then we'll pass orders at 2 after this. If there is no document, then they will get bail.
Yes, my lord.
Okay, I'll pass orders after this. If no notice under 48 is there, then you will get bail. I will verify it from records. Okay, I'll record your submissions. You need not to wait. Yes, Mr. Zolda.
So, my lords, if I may resume.
Yes.
So, my lords, it is what I'm trying to show from this document is that certain proceedings were happening before the learned.
But we don't know.
Which, my lords, which the petitioner knew. Ultimately, my lords, what the petitioner is trying to portray is that behind my back, no knowledge of whatsoever proceedings, an order has been passed, cancelling my validity of my pass. It is based on his representation itself, my lords. This is a very comprehensive representation of sale deeds, giving the facts, which I will not reiterate, my lords. Withdrawal order of the civil suit, if your lordship sees. So, my lords,
VC pass number 28 was issued in favor of Lian Chungi.
yes. No, my lords. In favor of my father, respondent number 5, Lian Tsungi, Kap Thianga.
No, father, where is it?
My lords, this is.
Where is father? Is it?
Yes. And my lords, thereafter it was gifted to me. That was our stand, my lords. We filed our affidavits also.
No, it gives an indication that
Yes.
on the basis of this VC pass number 28/1970, some representation was filed
By the petitioners.
by not the petitioners,
My lords, by the
Sangkumi and Lian
Lianchungi. Yes.
which they apprehended that some unfavorable order might be passed against them. Therefore, they filed this representation.
Yes.
It appears.
Yes.
But,
it appears.
But we do not know in which proceeding.
No, my lords. That only the government could have clarified.
Yes.
But
None. This has to be clarified. Otherwise, we cannot pass order in blank. Because one of the contention of the petitioner is that the impugn order has been passed at their back in violation of the principles of natural justice. So, to appreciate that submission, we would require the records whether any notice was issued to them or in what proceeding that this order has been passed. Or yes.
At hand, I do not have any such information and required, I may be allowed to seek instructions.
it is very clear from this that withdrawal application. Because if you see withdrawal application,
Which?
99, at page number 99. Here they say that they are trying to issue a pass in 99. With their second suit, they file and they withdraw again, then application 99. That's why we came to know revenue, they are trying to issue pass, then we file this representation. This is not so-called reply.
No, we cannot go to the documents which were filed in
The suit.
civil suits without, because now you are challenging a specific order.
My
So,
Lord, yes, it's true.
Order
My Lord,
which you are impugning.
My Lord, the contention, there is no reference that notice was given. Here, if there was notice was given, we'll say that in reply to your notice. Here we make a request. Because in
Yes,
my...
no, what I am saying that now we have to imply everything.
Yes.
Yes.
So on mere implication we cannot pass an order.
My Lord, one last submission is that if you see the impugn notification, if any proceeding is instituted or so-called notice was also replied, it must be written in the order itself. But if you read this notification, impugn notification, two of them, there is no such complaint filed by any of the party, and there was no mentioning of
Why
notice.
this order was passed? What prompted passing of this order? Only government can say, you have passed this order.
Well, no, let us not again, we are hard enough, because I have to go back to Delhi.
My lord, that is his problem.
Well, look,
That-
we
that
finished
is
everything.
totally unbecoming of a
Unless
lawyer.
the court understands.
But from the
They-
notification, it is very clear. And also their counter affidavit also, they did not mention that we give so-called notice to them.
Therefore a query, let the government,
Yes, that would be right.
At least today, my lord, can it be listed? And then they just make a call like what Linda had done.
no, not such a.
I will have to get a copy also.
Is there any stay in this?
No, my lords, not today.
There is a reference of some,
Yes.
there is a reference of this order. This reference must be in respect of some file in which that order has been passed. If you go through that file, you will find out what prompted the state government, because your affidavit filed by the state government is not clear. You have only defended the order. Let them, I am putting a query. Let the government place before this court the records in which this order has been passed.
Notice, whether notice was issued or not also.
No, everything will be clear.
Correct.
Yes, that's it.
This is item number
15.
heard Mr. J.C. Lalnan Sangha, learned counsel for the petitioners. Also heard Ms. Lalnan Louis, learned government advocate appearing for respondent number 1, 2, 3, as well as Mr. Jordan Romin Thanga appearing for respondent number
5.
5. Who is appearing for 4?
None,
Ex
my
parte,
lords.
madam.
Stop. During the course of submissions, made by the learned counsel for the petitioner, it was contended that in this writ petition, one of the grievance of the petitioners is that the impugn order dated 6th September 2023, bearing memo number K 15011/141/2018-REV, passed by the Commissioner and Secretary to the Government of Mizoram, as well as the another impugn order dated 20th September 2023, bearing memo number D 28016/10/17-DTE within bracket REV bracket close /LSC, passed by the Director, Land Revenue and Settlement, Mizoram, whereby the LSC number 204/ of 1989 as well as 203 of 1989 of the present petitioners were cancelled without affording any opportunity of hearing to them. Hence, a query was posed to the learned government advocate Ms. Lalnan Lui that in what prompted the respondent number, who passed the order?
Respondent number 2.
To pass the impugn order.
Manoj, can there be any specific order regarding notice? Because
And-
they can be disputed again if they do not clarify specifically.
And stop. It also appears, it is also not clear that in who initiated the proceedings before the aforesaid authorities, which culminated in passing of the impugn orders, as in their affidavit in opposition, the state respondents have not clarified this aspect. It is also not clear as to whether the petitioners, whose land passes were cancelled, were heard by the said authorities before passing the impugn orders. Stop. On this, learned Government Counsel Ms. Lalnan Lui submits that presently she does not have any instructions in regard to the query posed by this court. Hence, she has sought how much time? One week time.
My Lord, can we fix on at least 26? This last week I'll be in Mizoram till.
Okay.
Any day on last week.
Some time to seek necessary
23rd to 27?
clarification. Stop. The state respondent is directed to produce the relevant file in which the impugn order has been passed by the respondent authorities before this court, and if necessary to also file an additional affidavit in that regard. Let this matter be, Michael, 20, which date you will be convened?
23rd to 27, any day.
27. Let this matter be listed again on 27.
Well, actually Friday, sometimes, when just they have to leave early, 26, can we have on 26?
26, okay, 26th. 26th of February. List accordingly.
My Lords,
Much obliged.
just one query, my Lords. Part 2, Item 3. My Lords, I am amicus there. It's a POXO matter. Your Lordships would be not taking that up, I suppose, my Lords. It can be listed any other time, subject to convenience, my Lords.
Item number 3. Who is on the other side?
My Lords, Legal Aid Counsel, Miss Emily is there, and I believe Miss Mary is there for the state. If your Lordships is hearing it, my Lords, I can call the counsels.
Today I am not hearing. We'll take it up tomorrow.
Tomorrow.
It is in the hearing list.
It is in the hearing
We'll
list.
pass orders tomorrow.
My Lords.
This is the only matter remaining. We'll take up hearing list tomorrow. Pass orders, all of them.
Lordships.